for hearing on the for pretrial. And then case 2020 CF, 8232 is on for hearing on the motion. Case 21 CF 2332 is on for pretrial. Mr. Robinson is present. Mr. Robinson, if you'll look at that big screen there to your left, do you see your attorneys on the Zoom screen?
Yes, ma'am.
All right, and counsel, do you see and hear your client as well? And both of you are muted.
Yes, Your Honor. Good afternoon. Christopher DeCoste and Tara Kowals on behalf of Mr. Robinson. We can see and hear him.
All right, very good. So, of course, we had set this matter for legal argument and hearing today on the state's motion to compel the digital scan and on the response or amended motion to, strike the state's motion, but in other words, to object to the state's motion to compel the digital body scan. And so are both sides ready to proceed?
Yes, sir.
Okay. Mr. Robinson, you can have a seat at the table there if you wish, because the lawyers will be talking throughout this. And so it is the state's motion, so state, you may go first.
Yes, sir.
Your Honor, if I can ask a question, I couldn't hear Ms. Kowals. Could the court?
Well, I haven't heard her say anything. Ms. Kowals, can you hear me and see me? Looks like she's frozen at the moment. If I recall, did you say, is she making the argument in this case?
Is that better, Judge?
Oh, now I can hear you. Your video is frozen.
Is this better, Judge?
There we go. Now yes. Yes.
I was on the wrong router, so I put mine to the closest, so that's why it was on stable. I apologize.
Very good. I can hear you now very well. All right, so I had asked, were both sides ready to proceed?
Ready, yes, Judge, on behalf of Mr. Robinson.
All right, thank you. Then state it is your motion, so you may go first.
Yes, Your Honor, thank you. The state filed a motion to compel in this case regarding a digital body scan of this defendant, Mr. Robinson, citing the rule of criminal procedure 3.22C. Specifically, what the state is requesting is that a company, Complete Digital Forensic Solutions, be allowed to utilize digital scanners to simply scan Mr. Robinson's body. This will allow them to ascertain his height as well as the dimensions of his body, including the length of his arms, the length of his legs, and get all of that data information, and they can then use that for analysis in this case as opposed to the dashcam video that captured the murder on January 15, 2020. And Judge, based on the rule, I believe the state is entitled to obtain this type of evidence. It is not any different than taking a photograph or a video of Mr. Robinson. It is less invasive than a DNA swab. We're not actually probably touching Mr. Robinson at all. There will be a digital scanner that will be set up that will rotate around Mr. Robinson and obtain the data necessary. I know in the defense's motion, they cited some concerns relating to whether or not this was actually an attempt by the state to reenact the crime scene. I can tell the court, tell the defense, I'm not attempting to recreate or reenact the crime scene. I have no intention of putting Mr. Robinson in clothes that match that of the shooter. I have no intention of giving Mr. Robinson a firearm, model or otherwise, or to strike poses that were seen in the video. The language that was used in the motion to compel indicated that Mr. Robinson may have to stand still for up to 8 minutes and be placed in various poses for short periods of time. And the reason I worded it that way was specifically because I did not want to get into a situation where to do the digital scan, his arm had to be at a 45 or a 90-degree angle and then go to a different angle and have an objection because I didn't specifically put what pose he would be in for the digital scan. But again, I'm not attempting to recreate the crime scene, and I don't believe that comparing his height to that of the height of the shooter on the video once it's ascertained is recreating the crime scene any more than taking Mr. Robinson's fingerprints or DNA and then comparing that information to fingerprints or DNA at the crime scene is recreating the crime scene. And I would point out that the state has previously filed motions to compel both Mr. Robinson's DNA and his fingerprints, both of which were granted without objection. And so based on the rule, I believe the state state is entitled to this information. I think even in the defense's motion to strike their objection, they indicated that the state could ascertain Mr. Robinson's height with a tape measure. And so, to me, it appears that it's not necessarily the data that they are objecting to, but maybe the method. And I'm sure that they can clarify that when they make their argument. Additionally, they argued that Mr. Robinson's dimensions may have changed given the time frame that has elapsed from January 15th, 2020 to today. And while I grant the defense's position that an individual can put on weight and lose weight, which can change the dimensions, for example, your waistline, things of that nature, I agree with that. That is not what we're looking for. We're looking for his height, and bone structure does not change. And what I mean by that is, for example, the distance from your elbow to your wrist, that does not change. And so those are some of the dimensions and some of the data that can be obtained from this digital body scan, which we do believe to be relevant, because I do anticipate, and I believe the defense has articulated multiple times, that identity is going to be an issue in this case. The murder was captured on surveillance video. The face of the shooter was not, and so identity is something the state has to prove beyond a reasonable doubt in connection to this crime. And based on that, and based on the evidence available in this case, I do believe this information is relevant, and even within the defense's own motion, they cited description of the shooter from various witnesses. They cited that some police officers in their report described the shooter as between 5'6" and 5'8". That was actually, I believe, a reference to an individual that was seen running from the scene of the neighborhood where the home invasion robbery took place after the shooting. They also cited to Mr. Kruger, who had the dash cam video, and he described the shooter's height as somewhere maybe around 5'10", 5'11". So even amongst those descriptions, there is a fluctuation in terms of several inches. And I would point out that Mr. Robinson, we believe to be 6'2", but again, that's all based on self-reporting, which is why this information is necessary so we can verify the accuracy of his height and then compare that to the high-definition video which captured the shooter committing this crime.
All right, and I did want to ask, and you've already stated, but I want to confirm that there's no efforts to recreate any of the movements of the shooter that are observed on the video, or have him hold any objects of any sort in your efforts to get the height of Mr. Robinson and or the length of his arms and his legs and things of that nature.
That is correct. I just simply did not want to be limited by the language in the motion to a one specific pose, given the fact that they're going to bring in these digital scanners. And in the motion, I put up to 8 minutes. I think actually it will take less time than that, because I believe the plan is to bring in 2 scanners so that you can do the front and the back at the same time to reduce the amount of time, possibly up to as low as 4 minutes. But they may have to require him to extend his arms out so that the digital scan can get all of his body. And again, that may require raising an arm, lowering an arm, something of that nature, but I'm not putting him in clothes, I'm not putting him in anything to hold, and I'm not trying to recreate the specific poses that are captured in the video.
And have you by any chance, I didn't, but have you found any other courts in this jurisdiction, this state, or anywhere in this country, just curious, that have authorized or used a digital body scan?
Judge, I haven't found any case law specifically on that. I'll continue to look. I know that there have been previous examples of height determination in many cases that has been going on for a long period of time. A lot of times that takes place with an anatomical doll as well. This is a new form of technology. It's a digital scanner, but it's actually, my understanding, much more accurate. But that would be something that obviously down the road, once the results are in, if the defense, based on those results, sought to challenge that, we could have a Dahlberg hearing if necessary. But at this point in time, we're simply seeking to compel to obtain the data. And the technology behind this is not new. And that height determination, that type of thing, has been going on for a long period of time. But regarding these specific digital scanners, I don't have a case that I can cite you specifically.
All right, and all right, thank you very much. Then let me hear from the defense, Ms. Kowals.
Your Honor, I'm still, if Mr. Cooper is coming to this court to ask to do some form of testing to determine the height of Mr. Robinson, because that is what I've deduced out of everything that he has just said right now.
Well,
Why wouldn't you come in?
and the length of his arms and the length of his legs.
Why wouldn't you come in and ask for an X-ray? and then we'd have an independent radiologist take a scan of his body, an x-ray, and then determine the lengths of those extremities.
Well,
I agree.
so that seems to be an argument over method as opposed to data. And wouldn't you agree an x-ray then subjects Mr. Robinson to radiographic waves that he wouldn't otherwise be subjected to with a digital scanner?
Your Honor, the position that we are taking, and this is the problem, when the state cites to DNA, cites to fingerprints, cites to all those things, these are things that have been deemed reliable in the court system through decades. This company was incorporated in March of 2020 when the pandemic began. They have never testified in any courtroom before, and I could not find one case in any state in the United States of America or in any federal case that allowed a digital scan of a body to then be introduced to determine the height of our client. The other thing, Judge, is I still don't understand how he is saying, so what Mr. Cooper is saying is for the entire time that we have been in existence, all of every method we have ever used to determine the height of an individual and the length of their extremities is unreliable. And the only way to do this now is through a digital scan. They haven't cited through to anything that would allow this. It's actually not permitted in the rules. If they want to take a picture of him standing up, that's one thing, Judge. But what they're asking to do is to take a digital scan of the dimensions of his body. I don't understand what differentiates doing a simple measurement with a ruler as opposed to making this scan so important and necessary to put him through this. And Your Honor raised another thing too. How do we know that this digital scan doesn't subject him to some other form of radiation or anything that you had suggested prior in your question? This is the first time, Judge, this is the first case and the first thing in my history where I have ever had an issue where the state is asking to then take the height of my client to fit it into the video of the shooting. Why can't this company determine the height from the video? That is what is not making any sense to me. What do you need to scan Mr. Robinson for? And then when it moves over to the issue of probable cause, Judge, the state attorney's office is now taking the position that despite the fact that all of these civilians, independent and consistent with one another, including police officers, all of them are consistent. Yes, it's still a range, but it is not a range that Mr. Robinson falls into. Mr. Robinson is clearly taller than the highest range given by the only eyewitness to the shooting, who he himself says, I am 6'2", and I think he said he was even taller, or I am around the same height and weight as Mr. Robinson. And when we took his death people, that person was definitely skinnier than me and smaller than me. At the point that we are at now, Judge, I can't even fathom that Mr. Robinson in the state of Florida is even being charged with this case and is in custody when we have physical evidence, eyewitness evidence, all this stuff that says that he did not do this. The state is taking the position that all of the things that courts have relied on for centuries in prosecutions and to rest on convictions is somehow unreliable. And that we have now a new method from a company that doesn't even give us a CV. None of these people have any scientific history. They haven't presented anything about what this digital scan is about and the mechanics of how it works. They just come in and said, oh, we want to try this out on Mr. Robinson. And normally, Judge, we don't object. We didn't object to DNA. We didn't object to fingerprints because those are reliable, Judge. And if this was reliable, I would have no problem because you know what? Mr. Robinson is innocent and it would prove his innocence. But the issue that I'm having in this case is how this investigation has proceeded, that I do not trust the mechanism with which the state attorney's office wants to take his measurements in this case. I just don't trust it, Judge.
Well, I understand your position, but don't you think that's kind of moving a step ahead? Wouldn't that be, those arguments you're making, more appropriate for a Daubert hearing where we're testing and I then have to find about whether or not this is reliable scientific evidence and whether or not it's admissible. Right now, we're not talking about admissibility. Right now, it's simply a motion to compel evidence from the defendant. And as you stated, if these digital scans show Mr. Robinson is 6'2" or 6'3", if anything, that would probably support the defense position. It would be perhaps exculpatory evidence that the state would have to hand over to the defense once these digital scans are completed.
Your Honor, the defense position is that the state hasn't even met the bare scintilla of evidence required to even make this request of the court. This is not delineated in the time after an information is filed and subject to constitutional limitations that the court can compel the defendant to do certain things. This is not here. This is a new thing. So they don't have any precedent to ask for this. And it's almost like we are then saying, oh, do what you can to Mr. Robinson and we'll argue about the reliability of the scientific nature of these scans. The reason why fingerprints and DNA and all that stuff is delineated their handwriting is because that's already been established as reliable. The state can't just come into court and just ask for anything that they want. And separate and apart from that, Judge, is that in this case, they don't even have probable cause to ask for that. There is no probable cause in this case. The state themselves concede that without Dominique Barna, they didn't even have enough evidence to arrest him. And Dominique Barna's testimony, as found by this court, was impeached materially by the physical evidence and the testimony of all of the witnesses. Yet still, he is facing charges and he's in custody. But both of those are the arguments, Judge. There's no PC to ask. And this is just, it's at least Mr. Cooper could bring these individuals from Colorado who have no scientific history and lay out to the court exactly what it is before we subject or attempt to try to subject Mr. Robinson to any tests like this novel test that the state is presenting to this court.
Okay. All right, thank you. And you will have the last word then, Mr. Cooper. Rebuttal.
Yes, sir.
Your Honor, could I ask a question? I hate to interrupt, could I ask a question? I think that this may clarify one thing for the defense.
Okay.
With the computer generated, this is done a lot in Hollywood, that an actor will be scanned and then used for animation. So the question that I would ask to the government through the court is that with these scans, will there be an attempt to then recreate the commission of the crime with the data from the body scan?
You mean to create like an animation using the defendant's dimensions? Is that what you're saying?
Correct. It's done in CGI as well too. They
Sure.
scan the
This
body.
is not Hollywood, and that would certainly require a ruling by me to even allow that to happen. These computer-generated animations are few and far between, I get admitted, either in criminal or civil trials, quite frankly. But I'll ask Mr. Cooper then, is that the intention of the state? To create a computer-generated CGI-type animation using the defendant's dimensions that might be gathered from a digital scan to recreate the homicide?
No, Judge, it's the state's intention to ascertain his height and the body dimensions as I've previously described. And then once we have that information, compare that to the information that is on the video of the dash cam, the person that was chasing down and shooting the victim in this case, their entire body is captured on video. Based on a digital scan of the crime scene and a review of that video, this company will be able to ascertain mathematically the height and the dimensions of that person on the video. And again, by dimensions, I'm talking about height, possibly the length of their arms or the legs. Once they have a digital scan of this defendant, they can then take that data and compare it to the data that's on that video. But we are not making a movie of this defendant gunning down the victim.
Okay.
The
All right.
problem is, the computer is wearing long clothes. You have no idea what's underneath those clothes.
Well, again, we will, I'm sure, address that at a future hearing, depending on what the witness from this company may say, presumably after you'll depose him or her. I have no doubt that will be something that this court has to address. But that said, now that the question's been answered, then go ahead with any rebuttal that you may have.
Yes, sure. And just one thing to point out, the articles of incorporation that the defense referenced regarding this company on March of 2020, that is not when the individual that owns that company began doing this work. He's been doing this work for over a decade, I think actually closer to 20 years. And so he is not a novice, he is not a new person to this field. He is a new business owner. He has worked for other people in other capacities and has created his own business, which was in apparently March of 2020. But again, that is not the time that he began working in this field. Secondly, Judge, with regard to the digital scans, this is, again, it seems to be from the defense, not so much an objection to obtaining the data, because they keep going back to, these are new scans, these are new devices. They really aren't. They've been used in other fields and used in construction and engineering to take very accurate measurements in a variety of fields. But to say the state is entitled to get this information, or we would be able to get it through an X-ray or a tape measure, again, we're going back to, we're arguing over the method as opposed to what it is I'm actually seeking. And again, this is just a motion to compel. Once we get that data, and I said this before and I'll say it again, my expectation is, and the defense can correct me on this if I am wrong, but once we do these scans and compare it to the data from the video, if it is in any way exculpatory to this defendant, I highly doubt we're going to have a Galbraith hearing issued by the defense. But
Wait, so you're going to drop the charges if that's the case?
Well, let him finish his argument. Go ahead.
if it doesn't go their way and they want to file a Galbraith hearing, we will have a hearing, and that is down the road. And I fully expect that to take place. But at this part of it, at the stage of the process, we're simply trying to get this information, and we will compare it to the data, and I believe we're entitled to it because, and again, there's probable cause in this case.
And that was my question. That's one of their arguments, is you don't even have probable cause to ask for this digital scanner. Tell me about that.
And Judge, I'm not sure if their argument is I don't have probable cause to believe that Hakeem Robinson committed this crime, or I don't have probable cause to believe the data in terms of his height is relevant to these charges.
The crime.
To the crime. And I would point out, as it relates to probable cause of the crime, that Your Honor sat through a very long arbor hearing where some evidence was presented, not all of the evidence, and I doubt very seriously that the defense is contending that Your Honor found there was not probable cause to believe Mr. Robinson committed this crime when a bond of $1 million was set. If Your Honor felt there was no probable cause to believe that Hakeem Robinson committed this crime, I believe you all quite confident he'd be out on an ROR. But there was evidence to support probable cause that he committed this crime. There was, I know they keep referencing Dominique Garner, and yes, Dominique Garner has provided testimony. There's also DNA evidence from the vehicle in multiple places that matched this defendant, the vehicle that was used during the commission of the murder, and that then fled from law enforcement officers. There was an officer that testified that at the bond hearing that I know the defense has made a lot to do about regarding seeing two people exit the vehicle, not three. What was not available at the time of the hearing, which has since been provided to the defense, is a second video from a different house in the area, and on the video surveillance, one of which was provided to the court that showed two individuals jumping through a backyard, jumping over fences. The second video, which they have, shows another individual, which appears to be wearing the same clothing as the shooter, running in a different part of the neighborhood in the opposite direction, and they just so happen they're on the timestamp at the exact same time, which corroborates that there were three people involved. We also have this defendant's prints on a firearm that was found in that vehicle. We also have this defendant on Instagram after the murder, posting to social media where he is at a salon getting his toes done, and the caption is, "Just killed a nigga, now getting my toes done." There is other pieces of
There's
evidence.
speculation or relevance as to that, because they didn't even present that at the Arthur hearing, Judge.
Actually, it was part of the affidavit.
It was. I recall reading that and being familiar with that as part of the affidavit by the detective. But I'm just having him outline what he believes is the probable cause that justifies the request for the digital scan. This is obviously, I'm not making factual findings as to these things, but go ahead.
And Judge, those are some of the pieces of evidence. That is not the entire state's case, but that is certainly sufficient to justify probable cause that Hakeem Robinson committed this crime, and as well as there are multiple co-defendants that have been charged. And so that would be my response as to establishing probable cause that a crime was committed, and secondly, probable cause relating to the necessity to obtain his dimensions, his height. I pointed back to the defense in their own motion. They're saying identity is clearly an issue, and they are saying that multiple witnesses have given a range of heights. Some say 5'6" to 5'8", some say the eyewitness that they point out that on the dash cam, 5'10" to 5'11", and there's a range. Well, 5'10", 5'11", 6'2", you're off by about 3 inches. And Your Honor saw the video of the shooting, and the video of the shooting, though it was quick, the person that was responsible was running and kind of punched over as he's chasing the victim. And so I would submit that a difference of 3 inches isn't that much, and the person that gave that deposition was, if I remember correctly, 6'4", and he wasn't perfectly comfortable saying, I know for sure this is the height of the person, but he did say, I believe he was shorter than me, and they quoted 5'10" to 5'11", somewhere in that range.
So the guy whose car had the dash cam was 6'4", he testified?
Yes, and he was in a big truck sitting up, and this happened in a matter of seconds, surrounded by gunfire. And as they quoted, I did not verify, based on the depo transcript, exactly how he articulated. I'll take the defense of their word when they quoted it, and it said 5'10" to 5'11", somewhere in that neighborhood. But again, we're talking about potentially 3 inches. So based on that description, based on the physical evidence that connects him to this crime, based on other statements from people that were present, I believe the state has probable cause to seek this information, and it is relevant, and it will either inculpate or exculpate him.
Okay. All right.
And Your Honor, just before you issue your ruling, I would also like to, in the event, depending on what Your Honor rules, if Your Honor rules and orders that the state is allowed to take this scan, the defense is going to request that we be present. We are going to request that the entire process be recorded. And I also want to bring your attention to subsection 2 underneath the Florida statute, where it says that provisions may be made for appearances for such purposes in an order admitting defendant to bail or for providing pretrial release. So I would also urge tenants that this motion make a motion for pretrial release if the court is inclined to grant the state's motion to facilitate the request of him submitting to these scans.
So let me ask the state now, based on those requests. First, is there any objection to defense being present should I order these scans?
Absolutely not, I will.
Okay. And then second, and I don't know who would pay for the video. I mean, I assume if you all wanted videotaped, you all would pay for that to take place, right? Okay, they're holding up their iPhones. And what was the third thing? Oh, how would this get done? If I order this, how is this going to get done? As you know, the jail's a little tight right now. They're not letting folks in. I don't know how a digital scan would take place of Mr. Robinson.
One of the possibilities, and I put it actually in the motion, and because, again, Mr. Robinson's not the only person that's going to be getting digitally scanned if the court grants this order, would be to have him checked out, to be brought over to the police memorial building. We may be able to do this in the interview room that could record it. If it's big enough to accommodate Mr. Robinson in the scan, and they would be able to be present and
Oh, like one of the detectives interview rooms?
correct. That's a possibility. If not, I'm sure we can, because it'll need to be a secure area for obvious reasons. But I think we have a room over there. If it doesn't fit in the interview room, we can clear out the space that is secure, and that we can have it set up, and that either or both of Mr. Robinson's attorneys can be present, and they can watch it. And that actually might be better, because with them present, if the court orders this, I know they had a concern about law enforcement using reasonable force to make sure Mr. Robinson was in the correct position. I'm sure if the court orders this and they are present, they will have conversations with their client and he will comply.
Okay. All right. Okay. Well, I did as much research probably as all of y'all to see about this process and procedure. But having heard and considered both the state's motion, the defendant's responses, and the arguments today, I am going to grant the motion to compel the digital body scan. We will get to the point, should we need it, to have an appropriate Daubert hearing if there's a question about the reliability and the scientific nature of this scanning. But for now, I do believe the rules allow for the state to take this digital body scan under the rules of discovery. Of course, I will allow counsel to be present, and counsel can report if you so choose. I'm going to deny the motion for release. If this can be done at the Duval County Jail or in a detective or police memorial building interview room, then that's what it will be. But I will say, Mr. Cooper, coordinate with counsel and, of course, with the folks who are going to do this and with the Duval County Jail to see how that can take place.
Yes, sir.
And to find a mutually agreeable date and time for this to happen. If you would please get me an order to sign regarding that, including those provisions in there, then that is my ruling on this matter. Any questions from either side? State?
No.
From the defense?
None for myself, Your Honor.
Okay.
Very very briefly, Your Honor, just access to the record on one topic.
Uh-huh.
Mr. Cooper referenced a new video. And Ms. Kawase handles the legal side always on stuff. I'm on the factual side and the scientific side. So Mr. Cooper had brought up a new video that was sent over. And of course, in our hearing, we talked about whether it was 2 people or 3. In the scenario that we presented of 3 people, it's important to note that the witness, Officer Collins, stated to Detective Gibson, I just want to read this quote into the record, 2 black males fled from the vehicle on foot in an eastern direction, while the black male Officer Collins originally saw with a firearm fled westbound on foot, still in possession of a firearm. He described him as slender, 5'5" to 5'8" in height, wearing a black and gray hoodie and black sweatpants. So whereas not to litigate this more, but whereas A.S.A. Cooper has tried to minimize 3 inches, that puts it at a range of almost half a foot by a trained officer who, as he testified, is trained and testified in depot, trained in ascertaining the height of people. So just want to put that in the record. Thank you.
Okay, thank you. All right, let's pick a new pre-trial date for both of Mr. Robinson's matters then. Considering this has to get done, I suppose, I don't know, another 30 days?
Yes, sir. I believe and I'll refer to defense counsel as well, probably looking at September to have the scan done, if it can't be done in August. So I suggest a pass date in September so that hopefully at that time we can have that accomplished. If there are any issues, we can address it.
So maybe a late September date, does that work for everyone? I could do either September 28, 29, or 30 for the next pre-trial conference.
Unfortunately, Your Honor, it doesn't. On September 20th, myself and Ms. Kawase leave to go to Tallahassee for a retrial. That case, we're going to be in court for motions the week of the 27th. We've tried this case before. It is hugely demanding on the amount of stuff that we're going to have in that week before for pretrial. We start jury selection on October 4th, and the estimates are 2 to 4 weeks to try the case. Again, we've tried it before, so we know how long it would take, but we know that we will be locked down. Now, Ms. Kawase and I are also going to be in extreme measures to protect ourselves from contracting COVID, because if we get it, it is going to throw off that trial, and that trial has been more difficult to schedule than a NASA launch. We're also, Ms. Kawase and I are also cancer survivors, me with Hodgkin's lymphoma in 2013, her with breast cancer in 2018. So we're under a little bit different protocol. When it comes to arranging that room for the digital body scan, we're going to ask for a larger room. Just so that we can be distanced. We've been this way for a very long time, and it's a reason why we're not standing in your Honor's courtroom right now, because of the underlying conditions that we have that are different than others.
Well, I know the interview rooms aren't particularly large, and if there's going to be the digital scanner, Mr. Robinson, the 2 of you, no doubt some police officers of some kind, I don't know what other rooms they have available that record over at JSO. But I'm going to leave that to you all to figure that out. And so that's why I'm trying to give you all as much time as possible between now, August 11th, and the end of September. We're talking 7 weeks. But I heard you say you have hearings the week of the 20th. I'm talking about the week of the 27th. And as you well know, my pre-trial conferences are Zoom in, they last 5 to 10 minutes. It's just to get an update on the matter, to make sure the scan happened or didn't happen, and then we'll pass it again if it didn't happen. So I'm not asking for an inordinate amount of time, just to Zoom in to get an update on the case, to see if that digital scan has occurred in the next 7 weeks.
Respectfully, Your Honor, and I've asked this of federal judges, and I've had it granted, and I've asked it of all state judges, I cannot set anything that week. The amount of things that we have, we're essentially moving as well.
The week of the 27th, though?
Correct. With the amount of things that we have, with new evidence that we expect the same way will be dumped on us. The last time we did this trial, we were working 18-hour days for over 30 days. At minimum 18 hours, 7 days a week to schedule anything else. What I don't want is Mr. Robbins for us to rush through it, to forget it. If it can be done the week before, that would be great, but that week, the 27th.
I can put it on for the 16th of October, that's the week before, either 14, 15, or 16. I was just trying to give y'all an additional week to get the digital scan done. So 14, 15, or 16, tell me which of those days.
Of September we're talking
Of
about?
September, yes.
The 16th. Now, I have on my calendar, if it's Yom Kippur, I'm going to assume that the court is open on that day, though?
We are open, yes, we are open here. If you
Okay.
celebrate that holiday, I'll do it on a different day.
No, I'm Christopher, so if it's...
Oh, well, I mean,
That's all
okay. Okay,
And then
well,
personally, Honor, as well too, and what, if anything, even if we haven't done the scan by then, hopefully we'll have enough information to give to the court of when that scheduling will be.
and that's all my pretrial conferences are, it's just for me to keep my finger on the case and make sure that work is getting done and at least we're moving along. So September 16th will be the pretrial for both of these matters. That's your next